The next matter to come before the court this morning, or soon to be this afternoon, is Lori A. West versus Joseph B. West. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you plan to reserve any time as the appellant, please let me know, keeping track of the clock. The arguments are being recorded. They will be posted on the court's YouTube channel. For that reason, and I suppose others, please don't use the names of minors or victims. As I just indicated, it will be posted on the court's YouTube channel. The judges have read your briefs. We're ready to proceed when you are.
Thank you.
Counsel, would you like to reserve any time for rebuttal?
I would, Your Honor.
Do you know how much time?
5 minutes.
Okay.
I'm sorry.
That's okay. Thank you.
Good afternoon. May it please the court, Michael Ash on behalf of appellant Lori West. Equity, equity, equity. The overall spirit of 3105.171 is to provide equity in dividing a marital estate. Towards that end, a court shall make determinations as to property and divide that property equitably between the parties. Section C1 states that the division should be equal unless that would be inequitable. And Section E2 allows the court to make a distributive award of separate property or non-marital property in order to achieve equity. Now, in order to equitably divide the property, the court has to have values of that property. And that's what we're here today on. I've presented this court with 2 assignments of error, indicating that the trial court erred by independently determining the value of J&J Performance, Inc., the party's business, and then additionally the court erred by dividing the marital estate with the erroneous value that was determined. In this particular case, there was no business valuation provided. It's important to note that this matter was commenced in September of 2019. The matter was sua sponte dismissed for failure to prosecute, and in that dismissal, the court cited the failure of the parties to get tax returns completed, which included the business tax returns. Mr. West was the 100% owner of J&J Performance, Inc., and he had complete control of that company and its financial information, and he alone was who worked with an accountant to have taxes done. After the case was refiled and had 2 days of testimony, Magistrate Thompson issued a decision indicating that Mr. West had been uncooperative, had caused delays, and basically frustrated the discovery process. However, Magistrate Thompson did use the information that was able to be provided to calculate a value for J&J J&J Performance, Inc. She determined that value to be over $540,000. Mr. West filed objections, and the court remanded back to the magistrate with instructions to determine a book value and specifically gave an equation of assets minus debts to the magistrate. Now, this is a new magistrate. Magistrate Thompson had left the court's employment, and Magistrate Blake was now going to be reviewing the evidence that had been provided. No additional evidence was provided, no additional testimony. Magistrate Blake came back with a valuation of just under $30,000, a 95% devaluation of the company. It appears that Magistrate Blake did not include things like cash, and she may have included values of buildings that were lower than fair market value. This is not a new issue for this court. In my brief, I've cited, pardon me, 4 cases that I would like to point the court's attention to today. The first is Fetzer v. Fetzer, 2014, Ohio 747. Paragraph 34, this court states, a trial court's determination of value absent an abuse of discretion will not be reversed. However, failure to put on evidence does not permit a court to assign an unknown value, so the court itself should instruct the parties to submit evidence on the matter. Now, because there was no business valuation expert called, there was not testimony on this. But there is some testimony in which I'm cross-examining Mr. West about business records he has given to me and whether he knows if I gave those to a business valuation expert or not. There were also off-record conversations between counsel and the magistrate about the business.
Did you just say off-record
Yes.
conversation?
Okay. Secondly, the next case is, and I hope I'm saying this right, Soch, or Scotch, S-C-H-O-C-H, and that's 2019, Ohio 1394. In that case, this court held, trial courts have a duty to determine the value of all marital assets when fashioning a property distribution. Third is the Hunt versus Hunt, 2022, Ohio 412, in which this court held, if the value of a marital asset cannot be calculated because there was insufficient evidence presented to the trial court, then the matter must be remanded to the trial court for the purpose of taking evidence on the asset's value and readjusting the property division to allow for an equitable division of the marital property.
Counsel, do any of those cases require the court or the parties to have an expert to value a business?
I don't know if any of these cases required that. I can fairly confidently say that in those 3 cases there was no business valuation expert or an expert to value real property, which each case dealt with. There was no expert. But ultimately...
Can your client also have hired an expert?
Yes, of course she could have. And that was part of, I think, Magistrate Thompson's discussion in her entry and part of my cross-examination with Mr. West. Dovetailing that, the CPA who testified, and she is the party's daughter, so I don't know if she has bias towards one parent or the other, but as a CPA she testified, and the 2021 tax returns had not been completed. The 2020, 2019, and possibly 2018 all would need to be amended. According to the CPA, the records that she had been given, she had no confidence after the divorce process that those were accurate.
Because they weren't completed, you're saying the evidence is insufficient because they don't have the information?
I'm saying that, I'm not sure I understand your question.
You're arguing that it should be remanded back to the magistrate to determine the value of the business if there wasn't enough evidence submitted to the magistrate to make a valuation determination. Are you saying that part of that is that because that tax return wasn't done?
I think that's part of the reason is because that tax return wasn't done. Additionally, because the other tax returns may not accurately reflect the business income and possibly not accurately reflect business expenses that were taken, those have to be amended according to the CPA. And I think that will have a direct impact on the business value. Did I answer that okay?
Thank you.
Okay. The last case I wanted to bring up was Brady versus Brady, and that's 2013 Ohio 5314. And in that particular case, in sustaining appellant's assignment of error, this court held the finding is not supported by the record, and we must reverse and remand for the trial court to determine. In this case, two magistrates made calculations that are 95% different, $541,000 and $29,000. I think that shows that the court relied on its own determination of value. And the fact that they're so different seems to indicate that not only is there a calculation error, but that picking one over the other is arbitrary, capricious, and an abuse of discretion.
And counsel, you just have reached into that 5 minutes of rebuttal. You're at 4:38.
So, Your Honor, based on that, I would ask the court to remand to the trial court with instructions that a business valuation be done. I would prefer that, because it's a marital asset, marital funds be used so that we can then adequately divide the property. Thank you. I will reserve the balance of my 5 minutes.
Thank you, counsel.
Good afternoon. May it please the court, my name is Craig Reynolds. I am counsel for Joseph B. West and J&J Performance, Inc. There was a vast difference in the opinions or the magistrate's decisions at the conclusion of trial and after the matter, after the court ruled on objections and sent it back to the magistrate. Magistrate Thompson, who presided over the hearing, did not make her decision based on the evidence that was presented. She did perform a calculation based on looking at the tax return, and without any evidence other than the tax return came to conclusions. Her decision was so biased against Mr. West, she even chose to ignore his opinion of value of assets when Mrs. West agreed that the value was correct. There was a Challenger, a Dodge Challenger, that had been in storage that Mrs. West wanted. Mr. West said it was worth $22,000. Mrs. West said it was worth $22,000. And the magistrate gave that vehicle to Mrs. West and said she found it to be worth $10,000. Repeatedly, the magistrate found whatever opinion Joseph West gave, she wasn't going to accept it, and she was going to substitute her own decision. The trial court on objections reversed that as to each asset where there was evidence about what the value was. And none of those assets, golf carts, dragsters, none of those have been objected to. The only evidence was the evidence presented by Joe West. The trial court adopted those values, and the trial court remanded the sole issue of use the evidence that was presented to find a value for this business. The only evidence at trial was Joseph West. Mrs. West offered no opinion. Their daughter, the CPA, said, I just do the taxes. I'm not valuing the business. She was questioned about the values of depreciable assets on the tax return, and she said, those are the values that were there when I started doing the tax returns, and I've just been carrying them forward. But she had offered no opinion as to the value. Mrs. West could have sent someone out there to appraise the assets. Mrs. West could have given her own opinion as to what the assets were. This business was run out of a barn behind the West House. She chose not to give any evidence or any opinion or anything to the court about what all the assets were. Joseph West, who has been the sole owner and operator of this business for over 30 years, line by line went through the list of assets and gave his opinion as to what the value was. The magistrate didn't come up with the value out of thin air. She looked line by line at each asset, what evidence do I have, and she picked the only evidence that was presented, and that was Joe West's evidence. And she also said if Joe West is getting these assets, if she noted at least 2 of the assets were in Ms. West's possession, so even though the business owns them, Ms. West is keeping them, and she valued them that way. But she noted that Joseph West is getting the assets. He's taking all the debts, $112,000 of debts. And she did that. I noted in my brief the line and the page number where the evidence was presented on those issues. There was no other evidence at the trial court. And for the appellant to say, we need to remand this, there's nothing that the trial court can look at in the transcript that isn't in front of you. It's the testimony of Joe West as to what his business assets are worth. And to say, we'd like to have a business valuation done now, they could have had a business valuation done at any time, and they chose not to do so. And now that the court has adopted Joe West's opinion, they'd like a do-over. The trial court is required to value assets based on evidence that's presented. The trial court's not to just arbitrarily come up with figures where there's no evidence, and the trial court did not do this in the judgment entry that's in front of you. Certainly, the first magistrate's decision, I would say, they clearly did that. Just arbitrarily picked numbers out of the air by saying Mrs. West's vehicle's worth $10,000, even though she admits it's worth $22,000. The trial court issued a decision based on the evidence presented over 2 days of trial, and the only evidence is the outcome that's in the judgment entry. Is this decision supported by evidence? Absolutely. Is it arbitrary? No. If there were multiple pieces of evidence about the value, we could argue about that. If there was one person testifying about the value, and the trial court accepted that and issued its decision, there's nothing to see here. There's nothing to reverse. There's nothing to say, let's start over and do a business valuation because we didn't do one in the first trial. This decision is supported by competent, credible evidence, and the appellant's both assignments of error should be overruled. Thank you for your time.
Thank you, counsel. Attorney Ash, you will have 4 minutes and 25 seconds.
Thank you, Your Honor. I will not try to get in off-the-record discussions, but I will suggest that it is a little disingenuous to argue that Mrs. West did not attempt to or chose not to get business valuations, and I'll leave it at that. I will admit that there are no business valuations as part of the record, but I will also point the court to the nunc-pro-tunc entry that was journalized September 20th, 2022. And on page 9, second paragraph under J&J Performance, The court indicates that Mr. West shows a recalcitrance to cooperate in having the business value for division purposes. The court previously dismissed the party's case for failure to prosecute because after a year of litigation and the court's repeated orders for the parties to file income taxes and obtain a business valuation, the parties did not comply. Defendant failed to comply with outstanding discovery requests. Mr. West was the defendant. The defendant continued to delay the sharing of information, and as a result, certain taxes could not be completed, and in the absence of this information, the business valuation could not be timely completed. So the trial court acknowledged what the problem was. Now, for for appellee to suggest there's nothing to see here, the court made its decision, it sort of takes away the court's obligation that's imposed by 3105.171 to equitably divide the estate. That is the court's obligation. And if the court did not have proper information, I think the court should have continued the hearing and ordered somehow a business valuation to be done, rather than take two shots at it and come up with two values that are 95% apart. I think that this case, like Bailey, requires a remand with instructions. It doesn't matter how we got to there wasn't enough information. The point is, there wasn't enough information, and the court was not able to perform its statutorily obligated function.
Was there a request for a continuance on the basis you didn't have enough information to value the business?
There had been requests for continuances, yes. And after dismissing the 2019 case, continuances for not completing discovery were not met favorably. If there are no further questions, thank you for your time and your attention.
Thank you. Thank you both for your presentations today. The court will take a matter under advisement and we will issue a written decision, which we mail to all parties to this appeal, as well as posted on the Ohio Supreme Court website. We are adjourned until